Today's video is brought to us by the generosity of Firearms Legal Protection. Firearms Legal Protection is a legal defense program for lawful gun owners. You win the fight, and they will help you win the fight after the fight for the rest of your life. There's a link in the description for a coupon code for a discount for all active self-protection watchers. So guys, I'm sitting with Marc Victor from Attorneys for Freedom. And again, Marc, I just really appreciate you taking the time to really educate us all on some of these issues.
I think we all enjoy this stuff, right?
Yeah.
So let's just get to it.
So you've seen the video, and if you haven't, you need to watch it, from Milwaukee, of the dad waiting for his little one, gets, just knocked out unconscious by 4 teenagers who steal his car and run off. And I want to talk to you and ask you about, I had a lot of viewers on that video ask about the use of a firearm because, I carry a gun and could I use a gun here? And of course, I think it's pretty clear when he's knocked out some dude stomping on his head, okay, that's clearly a deadly threat to his life. Tactically, he couldn't have used a firearm there because he's out. But before that, as they push, as he comes out of his car, do you think, where's that line when I can say, aha, in this instance, I have enough provocation here to use my firearm?
Well, this gets to the crux of a couple of things. First, I think really this is a question about that I hear differently when it hits my ears. What I hear is, hey, Marc, I'd like you to predict what a randomly selected group of jurors in this particular community might think is reasonable under these circumstances. Right?
Sure.
We can try to predict that, but the truth is we don't really know, right? The other thing that I think is a very important issue, and I can tell you how we address this in Arizona, and I think it might be the best way to address it, is the question that I like to highlight sometimes with, you're carrying a firearm and somebody approaches you and in an unlawful way, they threaten ordinary physical force against you. Hey man, I'm gonna slap you in your face.
Oh.
And you got your firearm. You can't threaten deadly physical force in response to ordinary physical force. And so for many
Wait a minute, let's re-verify that. The attorney has just told you you cannot threaten to use deadly physical force in response to the threat of physical violence.
So let me just say generally.
Generally.
And then we're going to qualify that a little bit. But generally speaking, look, there's a continuum of force that we talk about on a regular basis. And if somebody is sort of just threatening, I used to just slap you in the face, because yes, this is an assault or a battery, depending on which state you're in, and it's unlawful, and let's say you didn't do anything you're not the aggressor, and somebody just says, hey, I don't like the look on your face, and they're going to slap you. And you got your gun, right? What you want to do is say, hey man, leave me alone, I got this firearm. That's what you want to do. But when you do that, you get charged with a crime.
Yeah.
Why? Because you threatened deadly physical force in response to ordinary physical force. So that's the problem, and I think that's the rub that's giving people some heartburn in this case. Well, in Arizona, we've come up with a statute to address this particular problem, the defensive display of a firearm statute.
Yes.
And it's
this is pretty recent.
Yeah, very recent, which is why we don't really have any cases that address the important parts of this statute right now. But this is an effort, in my view, to bridge the gap between the guy who wants to say, hey, I got a gun, leave me alone, no, you're not going to slap me in the face, and on the other end, the easy violation of threatening deadly physical force against a threat of ordinary physical force. So what we've done in Arizona is said, look, you can defensively display your firearm in response to ordinary physical force. So then what does it mean to defensively display your firearm? We give 3 examples actually in the statute. And first we say, look, if you tell somebody, hey, I got a gun, leave me alone, you just tell them that. That's actually displaying your firearm. Mm-hmm. That's defensive display in Arizona. Another one is when you put your hand on a contained firearm. Hey man, look at this, leave me alone. Now that people were getting charged with that before this statute.
Yep.
They were regularly getting charged with disorderly conduct. After this statute, this is now an argument. And then, of course, displaying your firearm in a protective manner, whatever that is. People say, hey, Marc, what's a protective manner? The last time I looked at this, which wasn't that long ago, we didn't have any guidance whatsoever from the courts in terms of what is a protective manner. So I speculate, right? I mean, of course, you and I know that a firearm could be used like this in a protective manner. That's, to me, I would love to argue that. I don't think you want to be the guinea pig in that case, because Probably not what the legislature was thinking. So what I think is probably a safer bet here is to maybe hold the firearm either up or down
Right.
while backing away and making it very clear, hey man, I'm not looking for any trouble, leave me alone. That probably passes muster as a displaying a firearm in a protective manner. But you know what? People still get charged with these.
Right.
And the goal is to avoid the prosecution, which is why I like to say, look, if you can retreat safely, that's probably your best bet. So in this situation, to get to this video, this guy doesn't really have an option to retreat, right?
Yeah, he's got nowhere to go.
So we have to look at it and say, okay, at what time, at what point would it be okay for the guy to pull out the firearm? Well, if we got an imminent threat of not just death, but also serious physical injury. Well, to me, he's one guy. It's hard to know exactly from that video. I couldn't tell what his age is. We don't know anything about his sort of physical, he may have just had open heart surgery. We don't know exactly what his situation is. But there's 4 of them and there's 1 of him. And to me, if I'm on that jury, I think that the guy is at risk of an imminent risk of at least a serious physical injury. And it looks to me like we probably saw that on there. I think he did suffer a serious physical injury.
He definitely did, yeah.
Well, it's not just death, it's also serious physical injury. So, if it's me and I got a firearm, I'm going to pull it pretty early on in that event and say, hey man, leave me alone, and I'm gonna rely on the defensive display of a firearm statute. Now, if your state doesn't have that, you're in that sort of black hole area where a prosecutor might very well say, hey, look, you can't pull your firearm. Now, on the other hand, you don't know what these guys are going to do. We have the benefit of hindsight.
Yeah.
We can look and say, okay, they punched him in the face and then they took off. They could have killed him too. They could have pulled out a knife and knifed the guy.
Well, stomping on a downed opponent with a shod foot is definitely an indication of the desire to do at least serious physical harm, if not death to someone.
Yeah, I don't think, and this is just me speculating, and I don't know about the juries there, but my guess is he probably does not get convicted if he uses the least amount of force that's reasonably necessary. Now, if he puts the gun in people's faces, and obviously if he pulls the trigger, probably too much at that point. But if he pulled it out and we saw an escalation, hey man, leave me alone, I got a gun. They don't leave him alone. Then maybe we take out the gun. Hey man, leave me alone, I got a gun.
I'm serious about this.
Right, I'm really serious about this. So if we saw that and these guys were still coming, that kind of thing, you're probably okay. But this guy, sometimes trouble finds you.
Well, and he clearly wasn't looking for trouble. I mean, he's just sitting there waiting for his kid to get done with soccer practice, right? And trouble came his way. But I think what I'm hearing you say, and correct me if I'm wrong, is that the presence of multiple attackers definitely tips the idea of disparity of force in the favor of the defender.
I think there's no question about that, because they're clearly working together,
yes.
Right? You got all 4 people working in concert here, and when you got 4 against 1, that's the kind of thing that, as a defense attorney, that's going to make me happy in a self-defense case, because you got it on video. Now, keeping in mind, without the video, right, you get into a dispute over what the facts are.
Right.
Because he says, I pulled out my gun, and then the other 4 guys say, oh no, we just stopped by, we were going to ask him for directions, and the guy pulled out a gun and shoved it in our face, and this and that. So that's the other thing you got to be careful about. When I talk to gun guys about these types of issues, people like a given set of facts. They say, hey, if this happens, can I shoot him?
Yeah.
Well, life doesn't come like that. I get a police report, I get 5 different witness statements, there's people change their stories, and sometimes I'd say, well, under those facts, we're okay. But I can't tell you how many times I'm on the phone or in person with a prosecutor on one of these cases where I'm laying out a set of facts that's really great for my guy.
Right.
And at the end, the prosecutor says, well, that all sounds great, Mark, but those aren't the facts I'm working with. I got a different set of facts over here from the victims. So especially in a case, this is the flip side of the 4 against 1 situation. You got to keep in mind, you're one witness, and not only are you one witness, you're the most biased witness in the entire courtroom. You're the defendant. You're the guy that's got the most to win or lose, right? And everybody knows that. And then you got the 4 people on the other side who are the victims in the criminal case. So you're already starting from a position behind, and it's sort of this strange set of circumstances where, you're more likely to need to use self-defense because there's 4 of them over there and 1 of you. However, now there's 4 witnesses on that side and only 1 here. This is the kind of thing that always causes me to say, look, let's be very conservative here. why don't you lock your doors so this doesn't happen? That's probably the smarter play, right?
Now when we gain a tactics advantage, then we don't have to worry about having the legal advantage.
You gotta use your brain.
Right. And of course that disparity of force can change if depending on who I am, because if I am, a champion UFC fighter, then maybe those four, I'm like, bring it, I'm fine. But if I'm a frail elderly person who's just had surgery, it's a very different set of facts, right?
And the question is, what's reasonable?
Oh, and there we get to that again.
Okay, there's no escape from the reasonableness.
There's no escape. It's like the umbrella that's over everything, right? That it's reasonable, and not just reasonable to my 12 buddies who are all highly pro Second Amendment. It's 12 randomly selected jurors from your area.
So I like to say, because of this problem with what's reasonable, because of the disputes on what the facts are, to me, it kind of shakes out like this. If I'm going to pull my gun, I got to be willing to be prosecuted, right?
Okay.
If I'm not willing to be prosecuted over this, then to me, the risk of what's going to happen just isn't serious enough. So if I'm this guy in the car, right, and I'm looking at these four guys, and I got guys opening doors and coming into my car, and I just got hit in the face and this and that, I guess I don't know what's going to happen to me in this circumstance. I'm really worried about living through this attack. My attitude is, you know what, prosecute me all day long. I'm not dying here.
Prosecutor's a problem for tomorrow. This is a problem for right now.
Right now, I'm not going to, but you got to be reasonable about that. That's the key.
So there's an important key. This is why we do legal education and moral education, because then that way we can act more reasonably in the moment. That's why we train. I think if you're going to carry a firearm, you train so then that way you can think, so you're not panicking and you can stay reasonable.
Yeah, keeping in mind, you're not always going to be charged and prosecuted.
No, of course not.
But if you're not willing to be, then to me what that's saying is the other side, the risk, the threat that's out there just isn't serious enough.
To ignore that, yeah.
Yeah, I'm just saying, I got to look at it and say, okay, you know what? I'm willing to be prosecuted here. I'm willing to take that chance, and I'll pull my firearm because I don't want to be dead.
Right.
I don't want to be crippled for life or something. And if you're really following that rule and you truly in your head believe, so long as you're a reasonable person, right, that you are about to be facing a risk that the substantial downside of being prosecuted is still a smaller problem for you, then you're probably going to be okay.
Yeah, then you probably won't be to begin with, and everything will be fine. So once again, guys, that disparity of force boils down to the reasonableness standard. And so you need to know these things. So then that way in the moment, you act correctly. You do the right thing. Of course, what you said tactically, locking your doors, staying, paying attention to your surroundings, those kind of things. But also then morally and legally, so then that way you are in the best place possible to defend yourself. So
one other point maybe on the reasonableness standard. It's not what you think is reasonable, right? It's not a subjective standard of reasonableness. It's what the reasonably prudent person would think is reasonable. And so there is some guidance here that people can look at, right? And I tell people, if you really want to get what the law is in your jurisdiction, get on Google and do a search for the criminal jury instructions in your jurisdiction, because this is what the jury, if you get prosecuted, this is what the jury is going to be told about what the law is. And a lot of these, maybe somewhat confusing statutes are sort of boiled down into more of a layperson's, spoon-fed for non-lawyers, because there are some default settings on what's reasonable, right? Like we'll say, look, if the threat against which you're acting isn't imminent, well, then you're unreasonable.
there you go.
If you're defending a property with deadly physical force, well, you're unreasonable. There are some things that we can tell you in advance are unreasonable, right? If you're going to use self-defense because somebody said something offensive to you, we're telling you you're unreasonable. So know the easy default rules, right? Because there's harder stuff in between.
Yeah.
But here is what the jury is going to be told about what's reasonable and what's not reasonable. You ought to really, if you're going to carry a firearm, look, I'm totally in favor of knowing how to use the thing. You got to go down and you got to train. But a piece of this is also your responsibilities to get an understanding of what the law is. It's smart for you to know that, because this is what you're going to be facing if you're accused of doing something wrong.
Excellent stuff. Marc, thanks again, man.
Thanks for having me.